On the phone, Julie Samuels. She is from the Electronic Frontier Foundation, an attorney who is the Mark Cuban Chair to Eliminate Stupid Patents. Welcome to the program, Julie.
Thanks for having me.
So now I want to talk about this in general terms, but the idea of stupid patents is prominently on my mind because it is public knowledge now that a couple of major podcast networks have been sued essentially by this company called Personal Audio, which I guess claims to have a patent on the whole process of podcasting. Just give me an overview of what your sense is going on here, and then let's talk about these stupid patents in general.
Sure. So, unfortunately, what we've seen is that this is kind of typical right now, and it's really bad news. It's incredibly dangerous, both for our economy and I think our society at large. But what these companies do is they get really broadly worded patents that are hard to understand, that are vague, that tie up basic ideas that we all take for granted, like podcasting, like using open Wi-Fi in a coffee shop. And the patent trolls start sending these threatening letters, probably not unlike the one you unfortunately got, to customers, to end users, to sometimes small companies. In the case of the open Wi-Fi patent, they started going after small coffee shops and nursing homes, and they demand a licensing fee. And they say, if you don't pay us a licensing fee because we think you probably infringe our patent, we're going to sue you. But here's the catch. Patent litigation is one of the most expensive kinds of litigation. It costs millions of dollars, takes years, and, most people aren't in a position where they want to go through that cost, both financial and other resources that need to be displaced. So what do? They settle. They take the licensing fee, and you can understand why. It's a logical choice if you're trying to run a business, to grow a business, which is really unfortunate because what we see then is that these really, frankly, crappy patents and the patent trolls that use them as weapons, create what is essentially a tax on innovation.
So when this outfit sues these podcast networks, or presumably sends letters to other podcasts and says you should get our license, or have your patent lawyer take a look and see if you're violating our patent. Now, just I can tell you that from my own personal experience, we fired our patent lawyer some time ago here at the Majority Report, just because he was just really messy around the office, and so we just have not hired someone since then. But for instance, this in the case of what's happening with Corolla and these others. Their patent, basically, and this is the way that they describe it, is a system for disseminating media content representing episodes in a serialized sequence. That seems like just about every media, doesn't it?
Yeah. Well, and that's exactly the problem. So I think you've got to take a step back to kind of understand what's going on here.
I'm trying.
It's confusing. It's some people think it's slightly dry subject matter, but I don't, so that's good. Most of these patents are software patents. And until about 20 years ago, we really didn't have many software patents in the United States. So it's a relatively new phenomenon. And there are a lot of things that don't make sense about software patents. For instance, the technology moves so quickly, but yet the monopoly is for 20 years. So by the time the patent is granted, often the technology is obsolete. Or what we've seen, the data show that software patents are notoriously broad, notoriously vague. They don't make sense. Lawyers oftentimes don't understand them. Software engineers don't understand them. And then the patent trolls are able to take advantage of this really broad language and say, you infringe this, and even if you don't, it's so hard to figure out that it's going to take juries and expert witnesses, and who wants to spend all that money? So these trolls, for that reason, are able to shut down, or extract tons of money for these broad processes like podcasting.
Now, I mean, for instance, like, and I'm just getting this from Wikipedia, but I mean, it's clear that podcasting existed in the early 90s or even in the 1980s. Some form of disseminating audio content in this way. And
Right.
yet this company says that they filed a patent in 2012, and
Right.
that was based on another patent that they had in 96. How is it they're issued this patent? I mean, for stuff that has already existed.
Well, you bring up a good point, and there are a lot of concerns about quality at the patent office, about the quality of the patents that actually make it out of the patenting process, and those are really legitimate concerns. You are, of course, not supposed to be able to get a patent on an invention that either already exists or an invention that otherwise would be obvious. And, it seems that this patent seems a little troubling on its face. There are a bunch of different processes to challenge the validity of a patent. You can kind of file something at the patent office saying, "Patent office, you screwed up this patent. Let's revisit it. Let's re-examine it." But that costs thousands of dollars and requires a lawyer, and it's just not easy. And what's so troubling, frankly, about where we found ourselves in this situation is all these people who don't want to be before the patent office, like you fired your patent lawyer. You don't want to mess with the patent office. You just want to do your thing. You just want to do your business. But then you find yourself having no choice. You're really affected by this system that hasn't been set up to protect your best interests.
And the irony is, the idea of patents is in the Constitution, but this is a sort of a fundamental building block, but it's clearly being abused. So in other words, these guys, or let's just speak about it hypothetically speaking, go in, they file a patent because they have the cash, they know they can outlast essentially anybody that they go after, and it just seems to be sort of extortion in a way.
I think that's right. I think that's really fair. And, again, I think it's important to take a step back to understand kind of where the wheels fell off the system. I just think it's better to understand what's really going on. And that has to do with this problem with software. I firmly believe this. So think for a second about patents on pharmaceuticals, okay, on drugs. A drug company is developing a new drug. They need to take it through 3 rounds of testing at the FDA on animals, on humans, and on humans again. They'll oftentimes spend close to $1 billion developing a drug, and sometimes at the end of a decade and all that testing, they'll find out the drug doesn't even work in humans. So you can understand why maybe the government would want to incentivize that kind of investment by offering a 20-year monopoly in exchange. Hey, work really hard, develop this drug that'll be good for society, and we'll give you this monopoly to make your money back. It doesn't make sense with software. And that fundamental disconnect has really led to this problem.
And so what is the recourse? Is it statutory? I mean, I know that you've been working on legislation to deal with this. Tell us a little bit about that.
So I think that, to answer your first question, and I'll tell you briefly about the legislation, I think there is not one silver bullet right now, short of getting rid of software patents entirely. But there are a bunch of potential fixes that are happening that I think a combination of which would make the world a lot better. One of those is this legislation that's currently pending. It's called the SHIELD Act. It's in the House, and it essentially would require in certain cases that the patent troll who brings a lawsuit pay the fees and expenses of the winning party. So if the patent troll brings a suit and loses, it has to pay the millions of dollars it costs to fight. And that's important because part of what the troll business model, is premised on is this idea that it's so expensive to fight the trolls in court that no one does. So we're trying to level the playing field a little bit, right, to incentivize these parties to fight back so that the trolls can't just kind of walk all over everyone. There are some other things happening. There are court cases. There is a case right now pending in D.C. that could limit the scope of these dangerous patents. We're filing briefs there, waiting to see what happens. And there are also self-help options. Companies like Twitter have been really great on this. A company called Newegg just fought a really egregious patent troll and won. There is a academic paper right now that proposes what's called a defensive patent licensing scheme, where parties would all freely license their patents to each other and promise not to sue on them. I think that those kind of self-help remedies are also going to be really important to make the system work better for people. These are all things we're working on. In fact, we've got a bunch of suggestions up on a website called defendinnovation.org, where we're actually soliciting comments from people who actually work in the field, people who actually have companies, people who are actually software engineers, to find out what would help and what wouldn't help. And then we're going to take those comments to D.C., to the Hill, and say, hey, it's time to fix this problem. And people are listening right now. They care. People in D.C. are calling. They want to know why the problem is so big and what we can do to make it better. So I'd encourage anyone who's interested to go to defendinnovation.org and help us kind of push this forward.
Now, is it possible that there can be legislation to simply negate specific patents?
That's a good question, to go after certain patents. So there are some laws that determine what can and cannot be patented. So that's more subject matter. It's kind of subject matter specific, and we might be able to play around a little bit with that. But that's pending in the courts right now. And basically why that's relevant, and this, I hope it's not too in the weeds, but the idea is that the law currently says you can't patent an abstract idea. Because how can you own an abstract idea? That's an absurd proposition. And to many people, software and algorithms and the code that makes up the basis of these ridiculous patents is actually rather abstract. So that fight is being heard in the courts, this month.
Right. I mean, so in the instance of the podcast, if there's no particular mechanism, but rather just a concept of disseminating audio content online in the same way that you would, a blog post, right? I mean, because if it's, an RSS feed, essentially, that would be an idea, right? As opposed to sort of a specific tool, it seems to me.
Right, and that's a really big problem because, and the courts have expressed concern about this, so I'm hoping they will continue to. There is something to be said for a patent that just ties up a single invention and how you implement that one invention, but not the idea of podcasts, not the idea of RSS feeds. Maybe someone has some really novel way of presenting a single podcast. Okay, well, then let's talk about that. I don't even know what that might be.
Right.
But that's a way more reasonable proposition than saying all podcasts, all RSS feeds. That's absurd. And that's the kind of thing we're working really hard to fight against.
Now, what are the implications if these people who have been sued, what are the implications if they just settle? I mean, does that create any more basis upon which a court would decide, or is that that just creates more of a precedent in terms of just sort of the norms of the business?
Yeah, I mean, I think the worst part about that is it emboldens the patent trolls, right? It makes their business a little bit easier. It makes their business work a little bit more smoothly, and that's not ideal. Again, if someone's actually facing the situation, they probably need to talk to a lawyer. To find out their best course of action. There are plenty of lawyers, by the way, who will recommend ignoring the letters. Because the other thing that we see happens is so many of these trolls send out so many letters that they don't always follow up with everyone. Not that I'm recommending anyone necessarily do that. Everyone's got to decide what makes sense for their business for, in the moment they get that letter. So it's a complicated calculation, to be sure. But, we want to be in a world where those letters don't come.
Right. Tell me about it.
Yeah, I'm sorry you got one. And we're working hard, and we're not alone. There are a lot of folks working really hard to make that be the case.
All right. Well, I appreciate your taking the time today to sort of walk us through this. This is probably not going to be the last majority report. But who knows? But it's.
Well, I hope not. Let us know, and we're looking for the most egregious of these. Help kind of tell the story of just how bad the problem is. And there's one other thing I guess if I got another second I'd say about
Please.
that. Part of the problem we've had is that until recently, the patent trolls hadn't really been going after individuals or small companies or people who put out podcasts, for instance. And all of a sudden, that changed about a year ago. So now the problem, if you will, it makes good TV. It's a way more compelling story, for better or worse. But that's really gotten people's attention. So
from from these patent trolls' perspective, I mean, what do they think they have to gain for, hypothetically, let's say, coming after a podcast of this size? I mean, it's a decent size, but from a revenue standpoint, there's not we're not living large. Let's say, I mean,
right.
hypothetically.
Well, I mean,
speaking.
I think if you're the patent troll, it kind of looks for better or worse, it looks like a little bit of easy money. You don't need a lawyer to send out a bunch of letters, right? So it's pretty cheap to send out letters, and let's say you send out a couple hundred letters, a couple thousand letters, and you get a couple $1,000 for each one.
I guess that's like sort of the Nigerian 419 email scam sort of theory, isn't it?
I hate to tell you, I don't think it's that much different. And, what's so frustrating about it is what they're doing is legal under U.S. laws. So we're trying to fix that because right now the trolls are exploiting these loopholes in the laws that let them create this tax on innovation in our country, that let them create this extra tax on entrepreneurs that we don't think makes any sense, and we think it's bad. So we're trying to fix that.
Yeah, I mean, it's really stunning to see people abuse the system in this way. Essentially, just know that they can go after certain people regardless of the validity of their claim, but really just leveraging the idea of how expensive it will be to fight it.
I think that's right. And, if people out there are interested in learning more, EFF.org, defendinnovation.org, we're working really hard to try and make this even just a little bit better, though we're trying to fix it completely. But this isn't a good way to do business. This isn't the way to, fix everything else that's wrong in our economy. It's just not.
And finally, the Mark Cuban Chair to Eliminate Stupid Patents. That's really your title, isn't it?
That's my title. You got it.
Well, I got to say that we're also open here to the Mark Cuban sponsored Majority Report in the event.
I'll let him know. I'll see what I can do.
Thank you. All right. Julie Samuels, unless there's anything else you think I should know, hypothetically speaking, of course, please share. Yeah,
I think we talked. I think it was important to kind of talk about the scope of the problem, and the part that's hard about these instances is that it just kind of sucks. It sucks to be facing one of these, and I wish I had a better answer for you. But the one thing that is helpful, and I would ask people to do if they feel that they can, is to talk about it, because so many times the targets of these letters and the targets of the lawsuits are afraid the troll's going to come after them, or they sign some kind of non-disclosure agreement, so they don't want to draw attention to themselves. And that makes it harder for people like me to do our jobs, because we're in a position where we need to convince Congress and we need to convince judges that there's a big problem out there. And unless we can get people telling the stories of just the magnitude of the problem, it's more of an uphill battle for us. So I would say, tell your story, and if anyone else wants to tell their story, let me know, let someone know. We need to explain why this problem is so big so that we can get serious people to pay attention to fixing it.
All right. Well, I will be in touch, Julie. I appreciate your coming on and talking to us about this. And I wish I could say you allayed my concerns, but what are you going to do? Hopefully we need some reform in this instance. All right.
Well, we're going to fix it. We're going to fix it. It's just going to take a little time.
Julie Samuels from the Electronic Frontier Foundation, the Mark Cuban Chair to Eliminate Stupid Patents. Thanks so much for joining us.
Thank you.